Since this present suit pertains to breach of contract, refund of payment and compensation, all of which are civil matters and comes within the jurisdiction of this honorable court. Your Lordship, secondly and most importantly, in the contract between Ali Raza versus National Real Estate Corporation, the word may is used for arbitration, not shall. It means that civil court is not expressly barred from hearing this case. Your Lordship, in support of this stance, the council would like to present a case law which is reported as PLD 2016, Supreme Court, page number 121. Your Lordship, in this case law, the Honorable Supreme Court held that the intention of the parties to refer the matter to arbitration can be inferred from the language used in the document. Thirdly, Your Lordship, the nature of relief sought. The plaintiff is seeking injunctions and damages, etc., which goes beyond the scope of arbitration. Hence, this Honorable Civil Court has jurisdiction to entertain this suit. Your Lordship, there is another case law which are supporting the stance of plaintiff, which is reported as PLD 2014, Singh, page number 504. Your Lordship, in this case law, the Honorable Court rejected the application and held that, Your Lordship, I am seeking your attention to the last page of that reported judgment, the last page, Your Lordship. The Honorable Court held that sufficient reasons have been shown by the plaintiff for not referring the present matter to arbitration. The suit must be allowed to proceed and be heard on its own merit. The present application filed is hereby dismissed. Since Your Lordship, in the present case, the counsel for the plaintiff already submitted that the relief which plaintiff is seeking, like injunction and damages, that is not coming within the scope of arbitration. So Your Lordship, that's why this Honorable Civil Court must entertain this suit. Your Lordship, there is also another case law having title Pakistan International Airlines Corporation versus Mrs. Pak Saf Dry Cleaners, reported as PLD 1981, Supreme Court, page number 553. This case law is also clearly supporting the stance of plaintiff. Your Lordship, in this case law, the Honorable Court held that the mere existence of arbitration clause in the contract does not bar a suit or other legal proceedings in a court. Your Lordship, if the Honorable Court is satisfied regarding the jurisdiction, may I proceed toward the second issue? Your Lordship, the issue number second framed by this Honorable Court is that whether the defendant Ali Raza committed a breach of contract or not. Your Lordship, the counsel on behalf of plaintiff respectfully submitted that yes, the National Real Estate Corporation committed a breach of contract by failing to obtain the necessary environmental clearances for Green Meadow Residency project. The counsel have 5 submissions in this regard, Your Lordship. Firstly, that how NREC committed breach of contract, which is the main cause of action. Your Lordship, if we look at clause 3, para 4 of the contract of sale between the parties. Your Lordship, clause 3, para number 4 of the contract of sale between the parties. This para states that the defendant is responsible to obtain all environmental clearances and other regulatory approvals within reasonable time. Your Lordship, despite passing of 12 months, NREC failed to obtain necessary environmental clearances, hence they clearly committed a breach of contract. Secondly, Your Lordship, also according to clause 3, para 5 of the contract between the parties, the defendant NREC was responsible that in case if government halted the project due to regulatory approvals or any other reason, the defendant NREC was bound to inform the plaintiff Ali Raza within 7 days through a written notice. Your Lordship, the point to be noted here is that they also failed to notify the buyer Ali Raza within 7 days through a written notice. Hence, they also breached this term of contract and committed a breach of contract. Your Lordship, My third submission in this regard would be the legal provisions which has been violated. Your Lordship, Section 37 of Contract Act states that the parties to the contract must perform their respective promises. Failure of NREC to obtain regulatory approvals directly violates Section 37 of Contract Act 1872. Your Lordship, secondly and most importantly, Section 19 of Islamabad Real Estate and Regulation and Development Act 2021 is also expressly violated by the defendant NREC. Your Lordship, Section 9, Subsection 1 of Islamabad Real Estate Regulation and Development Act bound the seller to inform the buyer about everything as agreed between them and the contract. Your Lordship, as I've already submitted that they failed to inform the buyer Ali Raza within 7 days, which was their duty according to the contract. So Your Lordship, this violation also violates Section 19 of Islamabad Real Estate Regulation and Development Act 2021. Thirdly, Your Lordship, they have also violated Section 46 of the Contract Act 1872, which states that where no time for performances in the contract is specified, the contract must be performed within reasonable time. Your Lordship, the failure of NREC to obtain regulatory approvals within reasonable time also violates Section 46 of Contract Act 1872. Your Lordship.
So what would be the reasonable time here in the particular case?
Much obliged. Your Lordship, the reasonable time in this case is 12 months. Your Lordship, they failed to obtain the regulatory approvals despite passing of 12 months. Your Lordship, the point to be noted here is that CDA issued notice to NREC on 1st February 2024. Your Lordship, CDA halted their construction on 1st February 2024, while they entered into contract with Ali Raza on 1st March 2023, Your Lordship. Your Lordship, 12 months has been passed since they failed to obtain regulatory approvals regarding environmental clearances from Environmental Protection Agency, Your Lordship, since they violated this term of contract. If the Honorable Court is satisfied regarding my submission regarding the breach of contract, may I proceed toward the issue number 3rd? Much obliged. Your Lordship, the issue number 3rd framed by this Honorable Court is that whether the plaintiff right as consumer has been violated or not. Your Lordship, I am seeking your attention to page number 21st of the memorial. Your Lordship, the counsel on behalf of plaintiff respectfully submits that the question of consumer right is secondary to the main cause of action, which is the breach of contract. The plaintiff has approached this Honorable Court not as a consumer but as a contracting party whose right has been violated by the defendant NREC as evident from the plaintiff, Your Lordship. The counsel has two submissions in this regard. Firstly, Your Lordship, the plaintiff is not claiming consumer right violation. Your Lordship, we are claiming breach of contract as evident from the plaintiff file, which clearly states that we are claiming a refund of payment, compensation and injunction against further slot sale. Your Lordship, so my second submission in this regard would be the court has authority to make determination on consumer right violation. Your Lordship, although the plaintiff is not relying on consumer protection law and we are not claiming it under the plaintiff file, but yet, Your Lordship, this court has discretion to determine that along with breach of contract or consumer right is also violated or not. And if this Honorable Court determines that our consumer right is also violated, then we will also have the opportunity to approach the consumer court against the defendant. Your Lordship, the plaintiff's stance is clear regarding this issue. We are not claiming consumer right violation, we are claiming breach of contract. That's why we approach this Honorable Civil Court, not consumer court. Your Lordship, this does not affect the current breach of contract claim, nor does it require the case to be transferred to the consumer court, as we have not claimed it. We are only claiming the breach of contract. If the Honorable Court is satisfied regarding this issue, may I proceed toward the next issue? Much obliged. Your Lordship, the later three issues will be addressed by my co-counsel. Thank you, Your Lordship.
Can you tell me whether you have filed court fees, regular court fees in this judicial branch?
Yes, Your Lordship, we have filed.
How much?
Your Lordship, the fees, the submission of fees is not available on record, but this Honorable,
The value of the case property is 3 lakhs rupees, 30 lakhs.
30 lakhs rupees. Yes, Your
So how
Lordship.
much do we find the fee? How much court fee will be required to be filed?
Your Lordship, counsel is ignorant of that.
This is the very primary issue.
Yes, Your Lordship.
The plan can be rejected at the very initial stage when you have not filed the requisite court fees. Because you must mention in the heading of the plan that I have filed this, the value of the purpose of court fees is this, and I have filed this thing. For this purpose, you have to consult the Suit Valuation Act, which says that at least 15,000 rupees court fees is required to be affixed with the plan. If this is not affixed, no degree will be done in your favor.
Much obliged.
Despite that, you have a very good case.
Much obliged. Your Lordship, as this Honorable Court has, as Honorable Court decided this case to be heard, the fees is already paid by the counsel, Your Lordship. Thank you, Your Lordship.
Thank you, Your Honor. With due permission of the court, may I proceed with the fourth issue? Your Honor, the fourth issue is whether the dependent can successfully invoke the force majeure clause to justify the delay in fulfilling its contractual obligation. Your Honor, no, the dependent cannot invoke the force majeure clause, and the dependent reliance on the force majeure clause is completely unjustified. Your Honor, I have several submissions regarding this clause. My first submission is related to clause 6 of the contract parcel, which contains the force majeure clause. Your Honor, it states that neither party shall be liable for failure or delay in performance under this contract due to circumstances beyond their control. Your Honor, in order to invoke this clause, it is a necessary condition that the circumstances must be beyond their control. Obtaining environmental clearances was not beyond the dependent control, and it was due to the negligence of the NREC because, Your Honor, if we look at the text of the case, the dependent has submitted compliance report on 28th February 2023, and the CDA had issued notice on 1st February 2024. Your Honor, it has a gap of 11 months and 10 days. During this gap, the dependent has not addressed any query from the EPA, nor write any application to the EPA to obtain updates about the delay. Your Honor, it clearly shows the delay on the part of the dependent. Now coming towards the CDA notice. Your Honor, if we look at the CDA notice, CDA gives 30 days time to the dependent to do the compliance by getting the pending approvals of environmental clearance. Your Honor, the dependent did not do compliance within 30 days after receiving the CDA notice. So, Your Honor, it also clearly shows the negligence on the part of the dependent. Now, Your Honor, if we look at...
Please can tell me whose responsibility to clear the environmental issue? Whose responsibility to clear the environmental issue?
The dependent has the responsibility under the contract parcel because it was stipulated under the contract parcel that they will obtain the environmental clearance under the reasonable time.
You are a defendant.
No, sir, I am from the plaintiff side.
You are plaintiff side, you are from defendant side, not on plaintiff side.
I am from the plaintiff side.
The second also.
Yes, Your Honor. I am addressing the remaining three issues. Your Honor, if we look at the date of the CDA notice, 1st February 2024, and my client has filed the suit on 1st May 2024. Your Honor, during these 2 months, there is nothing available on the file which shows that the dependent has done something about the CDA notice. So it also shows the negligence of the dependent. Your Honor, now coming towards the onus of proof. My second submission is regarding the onus of proof. Your Honor, it is a general principle of law and jurisprudence. Whoever takes the shelter of general exceptions like force majeure, the onus of proof shifts to the party who is claiming it. Now it is upon the defendant to show that they have acted in good faith and the circumstances were not beyond their control. So, Your Honor, while from the facts it is evident that the defendant failed to obtain the environmental clearance due to their negligence. Now, Your Honor, coming towards the case law, the counsel shall rely on the case law cited as Atlas Cable Private Limited versus Islamabad Electric Supply Company Limited, reported as 2016 CLD, page 1833. Your Honor, in this case, the defendant has invoked the force majeure clause on the basis of international increase in prices. And the Honorable Court held that in this case, that the international increase in prices of particular material, which is metal in this case, is not sufficient to constitute a force majeure clause. So, Your Honor, according to this case law, the acts of government does not constitute the force majeure. Your Honor, if the Honorable Court is satisfied with the fourth issue, may I proceed towards the fifth issue? Much obliged, Your Honor. The fifth issue before this Honorable Court is that whether the plaintiff Ali Raza is entitled to claim damages beyond a refund of the amounts paid, including compensation for financial and personal losses allegedly suffered as a result of the defendant's breach. Your Honor, as already discussed by my co-counsel, that the defendant has explicitly breached the contract. So Your Honor, the plaintiff Ali Raza is entitled to claim damages beyond the refund of the amount claimed, including compensation for financial losses and personal losses. Your Honor, I have several submissions regarding this stance. My first submission is regarding the reasons for which I am claiming the compensation. Your Honor, due to the delay in possession, the plaintiff has been forced to continue paying rents for his residence. This dual burden of rents and flat installment is a direct financial loss caused due to the defendant's breach. Your Honor, the second reason, if the plaintiff has invested this amount in an alternative property or something where the plaintiff could have generated income from this investment. So, Your Honor, it also shows that we are entitled for the compensation. Third reason, Your Honor, the defendant's breach has caused the plaintiff litigation costs, including the court fee and the attorney fee. Now coming towards the fourth reason, the plaintiff has suffered emotional stress by managing both the house rent and installment fees. Your Honor, the plaintiff has also suffered emotional stress due to uncertainty about the project's completion. Your Honor, my second submission is related to the legal basis. According to Section 19 of the Specific Relief Act 1877, the court is empowered to grant compensation for the breach of contract. And Section 73 of the Contract Act 1872 establishes the right of an aggrieved party to claim damages for the losses caused by the breach. So, Your Honor, the plaintiff is claiming damages under Section 19 of the Specific Relief Act and Section 73 of the Contract Act 1872. Now coming towards the case laws. The court in this case held that damages for mental shock and torture fell in the category of general damages for assessment of which no dependent method was laid down. Primary consideration of court in such cases should be to compensate the plaintiff as far as possible for the injury caused to them. So, Your Honor, according to this case law, the compensation for damages caused by mental torture needs not to be proved. If the Honorable Court is satisfied with my submission in the fifth issue, may I proceed with the sixth issue?
Okay, can you point out